Well, good evening. I am your host, Bob Mata, and welcome to Defense Diaries. Maybe, if we're lucky, my beautiful and brilliant co-host will be joining us. We'll see. I hope she does. I know she knows nothing about this case, which we will be discussing tonight, which is the Lindsay Clancy case. It is just a brutal case. One that the fact pattern is just, it's one of those ones where it's hard to stomach. It's hard to fathom, but it is going to be a very interesting trial, because if you follow true crime, you know that many times things aren't always as they seem. And this one seems pretty cut and dry on the face of it. And as I kind of go through the fact pattern, which I'm going to do right now, just giving you kind of a loose timeline, you'll kind of understand where I'm coming from. But you have to dig deeper. You have to try to dig deeper in cases, because everything's not always as it seems. And this is one of those cases which I was talking about in our earlier live, when I was talking about Luigi Mangione. Oh, it's a Luigi Mangione. When I was talking about his mental health and the potential for that becoming a defense for him, that is very much the case here in the people of the state of Massachusetts, or the Commonwealth. I'm sorry. Commonwealth of Massachusetts versus Lindsay Clancy. So let's kind of dig into the yes, dear. I'm live now. Yeah. I thought I said 5:15. Hold on. I would love for you to be on it. Yeah, and I said 5:15 just for the record. Okay, so I'm going to give you kind of a basic timeline. I kind of want to wait because I actually want Allie to hear about this. I know she doesn't know anything about this case, and I know she's going to be interested to know the facts. We'll catch her up. We'll catch her up to speed collectively, though, right? We can all do that. So let's go back to May 26th of 2022. And I'm getting this information from an article that Dizzy had sent me, and Dizzy did people's work here, yeoman's work, in getting me all of the intel for this live tonight. She's got me all kinds of goodies, so I am eternally grateful to Dizzy for that. Mandy put together yet another fabulous thumbnail. I don't know if anybody's making better thumbnails than Mandy's these days. I got to be honest. I look at them, people have the block letters and try to use shocking language, and Mandy just stays classy. She's really putting it all together with those thumbnails. I'll tell you that. All right. So May 26th of 2022, Lindsay gives birth to Callan Clancy. So while Lindsay was public about her struggles with postpartum anxieties, her two older children, she posted on social media following Callan's birth that she is focusing on exercise, nutrition, and mindset, which quote made all the difference. Now that quote came from the Boston Globe. Let's move to September of 2022. So we've got Callan born May 26th. The summer's gone by. We're now in late summer, September. And at the end of Lindsay's maternity leave, as the end of her maternity leave approaches, she starts feeling anxious about returning to work at Massachusetts General Hospital. Now, that's according to her husband, Patrick. So, Lindsay visited two different psychiatrists and is diagnosed with generalized anxiety disorder. And that's what the assistant DA says later. Now, over the next several months, she is prescribed 13 different psychiatric medications to treat the anxiety, depression, and insomnia, including Klonopin, Valium, Prozac, Zoloft, and Ativan. Now, that comes from her attorney. Now, at that time, she's taking as many as 4 different medications a day, as prescribed, according to Patrick. Now, let's move to October of 2022. Lindsay writes a note on her phone that reads, quote, "I think I sort of resent my other children because they prevent me from treating Cal like my first baby. And I know that's not fair to them. I know that. I was feeling so depressed last evening when Cora and Dawson came home from school. I know it runs off on them. So we had a pretty rough evening. I want to feel love and connection with all my kids." End quote. And that's according to prosecutors. Let's move to December of 2022. Lindsay's evaluated at the Women and Infants Hospital Center for Women's Behavioral Health in Providence, where she is told that she has no symptoms of postpartum depression, according to prosecutors. Later in December, Lindsay says she is having suicidal thoughts and thoughts of hurting her children. Her husband, Patrick, told police. In January of 2023, Lindsay admits herself to McLean Hospital in Belmont on January 1 of 2023. She is discharged 5 days later. Hospital officials did not indicate that she is a danger to herself upon discharge. Weeks after her discharge, Patrick asks if she's still having suicidal thoughts, and Lindsay responds that she isn't, according to prosecutors. Later that month, Patrick asks the doctor treating his wife to help manage her medications, according to her attorney. He, quote, went to the doctors repeatedly saying, quote, "Please help us," end quote. This was turning her into a zombie. The medications that were prescribed were over the top, end quote. And that comes from Lindsay's lawyer. It's 1 week prior to the date that Lindsay allegedly takes the lives of her 3 children. January 22nd of 2023, family friend Kyle Carney invites Lindsay, Patrick, and their 2 older children, Cora and Dawson, over for dinner. Carney later tells police that he had not expected Lindsay to come because of her depression and had not seen her for months. Lindsay, quote, seemed fairly normal, end quote, that evening, but Patrick said she was suffering from benzodiazepine withdrawal a month and a half earlier and had, quote, the worst side effects possible, end quote. Carney later tells authorities, Patrick, he tells, hold on, I gotta flip. Is that Allie? Did she pop on?
I'm right next to you.
Aw, hi. I can't see you. I have a screen up.
Oh, hey, babe.
Hi, here's my beautiful and brilliant co-host, Allie. What's up, girl?
Pretty good. I got to leave at 6:30 though to pick up Scout.
Oh, you do? Okay. I'll
Well,
power
really,
through.
6:35.
Okay. So we're handling the Lindsay Carney case. She is a woman who stands accused. It is pre-trial. She stands accused of infanticide. She is alleged to have strangled all 3 of her small children.
Shut up.
So
Oh,
we're kind of going through the fact pattern as it leads up to it. You missed a little bit of it. Postpartum, she's on a ton of meds. She's been depressed. She's been suicidal. So we're 2 days prior to the homicides. All right. So and they had a little dinner party with a friend named Kyle Carney, and that's where we're at. So Patrick, who is her husband, also says that she had been having anxiety about returning to work, and the medications she was prescribed were not working, according to Carney, the friend. Lindsay's family also visits her and the family that weekend. January 23rd, 2023. Lindsay writes a note on her phone that said she has, quote, a touch of postpartum anxiety, end quote, about returning to work, prosecutors later say. Which brings us to January 24th, 2023, the day of reckoning. So the morning of the 24th of January of 2023, Lindsay takes Cora, 5 years old, to a scheduled doctor's appointment. When they returned home, they play in the snow with Cora's brother, Dawson, 3, and Lindsay sends pictures of the children to her mom and husband. Now we move to 4:02 p.m. Lindsay looks up kids' Miralax on her phone, as well as, quote, take out 3V, end
what?
quote. That's what it says. Take out 3V as in Victor, end quote, according to court documents presented by prosecutors. She then uses her Apple Maps on her phone to look up how long it would take to drive from the family's Duxbury home to 3V, a restaurant. There you go. Where was your brain at when I said that?
Like 3 victims, I guess.
Right. Right. I bet you when the prosecutors first saw that on her phone, they thought the same thing until they saw that it was a restaurant, which is a restaurant in Plymouth. 4:47, Lindsay calls CVS Pharmacy in Kingston and asks if they have children's Miralax in stock. The manager tells her they don't, but they have similar medications for children, and this is according to prosecutors. The manager later tells investigators Lindsay did not slur her words or sound impaired during the call. 4:53 p.m., Lindsay texts her husband, who was working from his home office in the basement, quote, any chance you want to do takeout from 3V? I didn't cook anything. It's been a long day, end quote, according to prosecutors. Patrick's response says, Patrick responds, yes. Were you going to ask something?
I just thought you could maybe just say in the beginning that it's according to prosecutors and then not keep saying it.
Oh, well, I'm reading it directly from an article. So,
Okay.
Yeah.
That makes sense.
which if it's Inside Edition, so, not to cast shade, but the writing leaves a little to be desired, but whatever. Patrick responds, yes. And Lindsay asks him to, quote, check the menu when you can, end quote, prosecutors say. Here, I'm going to switch it up for you. According to prosecutors at 5:10 p.m., after they text each other what they want to eat, a, quote, Mediterranean power bowl for Lindsay and the, quote, scallop and pork belly risotto for Patrick. Lindsay calls 3V to place their order. Prosecutors then say at 5:15, see what I did it again for you, Bay. Lindsay texts Pedialax liquid stool softener to her husband. Patrick then leaves to pick up the medicine and their takeout order. At 5:33 p.m., Patrick arrives at the CVS in Kingston, where he calls his wife to confirm what medication they need. She doesn't answer. Calls him back in a minute later. He later tells police that Lindsay seemed like she was in the middle of something when they spoke. 5:54 p.m. Patrick arrives at 3V, pays for their food, and then leaves. 6:09, according to prosecutors, Patrick arrives home and, quote, the first thing he noticed was the silence, end quote. He did not see or hear the defendant or the children, end quote. He calls for his wife, but there is no answer. He then goes to their second floor bedroom and finds the door locked. Patrick eventually gets into the bedroom and finds blood on the floor and an open window. He rushes outside where he sees his wife on the ground, injured.
Oh, she survived.
6:11 p.m. Patrick, she's going to trial, right?
Right. Obviously survived. Yeah.
So prosecutors say at 6:11 p.m., Patrick calls 911 to report Lindsay's attempted suicide. Lindsay can be heard saying during the phone call, quote, "I tried to kill myself and jumped out the window." Quote, "A female party jumped off the top floor of the house, impact injury, neck lacerations," end quote. Dispatcher could be heard saying in the audio recording, which we are going to listen to next, by the way. She's conscious at this time. It was over a 20-foot fall. Patrick asks Lindsay during the 911 call, quote, "Where are the kids?" End quote. She replies, "In the basement."
Oh,
End quote.
Lord.
While on the phone with the dispatcher, Patrick goes down to the basement and calls out for the kids.
I can't hear this 911 call.
Yeah. He can then be heard screaming in agony. Cora and Callan are found on the floor of the den. Dawson is found on the floor of Patrick's home office. Each child has an exercise band tied around their necks.
Oh, my God.
Patrick removes the bands and begs for them to breathe. Once officers arrived in the basement, he yells, quote, "She killed the kids," end quote. Lindsay is transported to South Shore Hospital in Weymouth, where she is treated for several broken bones in her back and rib cage. The injuries leave her paralyzed below the waist, according to her attorney. Her kids are transported to the Beth Israel Deaconess Hospital in Plymouth. 7:28 p.m., Cora and Dawson are pronounced dead at the hospital. Callan, the infant, is later transported by medical flight to the Boston's Children's Hospital. 7:29 p.m., a Massachusetts State Police trooper arrives at Beth Israel and speaks to the doctors who treated Cora, Dawson, and Callan. The doctor who treated Callan during his medical flight says he's in critical condition. January 25th of 2023, an arrest warrant is issued for Lindsay for 2 counts of homicide and 3 counts of strangulation and 3 counts of assault and battery with a deadly weapon. January 27th, 2023. At 11:18 a.m., 8-month-old Callan Clancy is pronounced dead at Boston Children's Hospital. It's later revealed that while medical staff were able to restart Callan's heart, his brain activity was never recovered following strangulation. He succumbs to his injuries days later. Later that day, Lindsay awakens and uses a whiteboard to communicate while intubated. Prosecutors say one of her first questions is, quote, "Do I need an attorney?" End quote. January 28th, 2023. Patrick posts an update on GoFundMe asking the public to, quote, "Forgive Lindsay as I have," end quote. February 26th, 2023. Lindsay calls her husband in the presence of a psychologist, her lawyer, that her lawyer hired to assess her mental state, according to prosecutors. She tells Patrick that after he left home on January 24th, she heard voices and had, quote, "a moment of psychosis." Quote,
What?
he asked, yeah,
I was just going to say, why in the hell would the psychologist that a defense lawyer hired have her making a recorded call talking about this stuff? Well,
it's
what?
weird. It's weird. It's weird in a lot of ways. It's weird that a psychologist would.
I mean, I'm just going to say this has got. I mean, she clearly was suffering from some kind of mental illness. I mean, this is just you don't
Yeah,
strangle your
the
3
story,
children.
based on this Inside Edition, everyone's going to want to, hang this woman up by her neck. There's more to it, though.
There's
So
got to be.
let's just keep digging in. So February 27th, 2023, on the day of Lindsay's arraignment, her lawyer says that she is still suicidal. Quote, "She's extremely emotional. However, she's unable and has been unable to express any happiness or sadness or cry. End quote. He states that in court. Lindsay has entered a plea of not guilty and will continue to be held without bail. And that is her next court date of May 2nd. All right. So that's what leads up to all of it. All right. So that's kind of the underlying story. Now, the next thing I want to do
Look at the
is
distracted therapist's comment.
what?
She said she worked with this case and people close to it.
Yes. Did you see my comments? I did not see her comments. I wasn't looking at the screen.
She might have been responding to someone else in chat, not us. But
Oh, okay. Okay. Well, good. Distracted. You are an excellent resource. Oh, Bob, I'm a social worker in Mass and work directly with her case. Happy to share a clinical perspective. That would be amazing. That would be amazing. I would love to hear that, actually.
yeah,
All right. So, distracted, just let us know how you want to go about doing that. And we'll kind of figure it out from there. All right. So, this thing that I'm going to pull up now is going to
oh, is
be
this the 911 call?
yeah. So just to trigger, I
Yeah.
mean, if like I haven't listened to it yet, so I don't know if it goes as far as to when he gets down in the basement. I'm kind of rooting that it does not, to be
That's
honest
what
with
I
you.
assume that it does. I mean, if you're rooting, you could just why don't you ask the people if they want to hear it or not? I mean,
What do you guys think? What do you guys think?
I think we hear it as hard as it'll be to hear, but I don't know.
Okay. All right, so this is it. All right, but trigger warning. Guys have all been warned. If you need to take a breath, take a breath. You need to step away, step away. Oh, this is excellent news. Thank you for that update. Legal Vices hit 100,000 today, so that the family can get the plaque. I told you the fellow law tuber
Yeah, you guys
passed
told me about it
away.
yesterday.
Oh yeah.
I didn't know that there was a plaque. I didn't know how the hell it worked.
Well, you get a plaque at 100,000 from YouTube, and he, much like us, put a ton of work into this, and it's part of his legacy. And I was really wanted to see that happen for him. So I'm really happy that it did. All right. So this is the 911 call. All right. Prepare yourselves.
I think this is the call from first. Dizzy says it's the call from first responders,
Oh, good.
not the actual 911 call.
All right. I'll rewound it.
Off the top floor of the house, slicer wrist as well, and neck injury, neck laceration. She's conscious at this time. We're going to check with med plate. It was over a 20-foot fall, 1814.
There's Patrick.
It's unknown where the knife is or whatever she used to slit her. She's in the. Looks like they're pinging around the back. We'll get that info now.
She did use a knife at first, unknown where that is at this time. Have the update, thank you. Roger, Max. I'll take DSC. Kingston 5 on-duty personnel, stand by for the evening radio and tone test.
Wireless, got a mutual aid ambulance.
I'm on the way. We're with the county.
I got two pediatric arrests in the basement.
I'm as a 2 pediatrics arrests. We got a mutual aid on the way. Mutual aid at this time.
All right. So 911 call comes in. They do not waste much time. All right. So the next thing we're going to put up is the update on the
So we don't
investigation.
have his 911 call.
Apparently no.
It
Apparently no.
Okay.
So I'm actually relieved. I
would have
don't
been
need-
hard to hear.
I don't need to hear it. I can imagine just how brutal it was. All right. So this is going to be an update that was given, I believe, 2 days after the fact. Okay.
Course of the investigation, we developed probable cause and today are seeking and obtaining an arrest warrant out of Plymouth District Court, charging 32-year-old Lindsay Clancy, the mother of these children, with their homicides. Lindsay Clancy, as I stated, is being treated at a Boston hospital. As soon as able, we will be arraigning her on the 2 charges of murders and the deaths of her children. As stated earlier, this is an active and ongoing investigation by the Mass State Police and the Duxbury Police. I want to further commend the professionalism and the work of the Duxbury first responders and the Mass State Police. I'm sure many of them will not forget what they saw last evening. And I think we should all be grateful to the men and women that put a uniform on, that are willing to do this difficult and challenging job. When something like this happens, there are obviously usually more questions than there are answers. As we proceed forward, we will give answers as we can. But we have, as I stated before, need to continue to do our job to put a criminal case together. So therefore, nobody's here to speculate. Nobody's here to talk about any motive of individuals. We're well aware of the fact that anybody charged with a criminal crime is presumed innocent until proven guilty beyond a reasonable doubt in all of our cases. This is an ongoing investigation, and certainly our heart's condolences go out to the Clancy family. I cannot begin to fathom the expressive, the pain, the depths of pain that must be going on. With that, I'll turn this over to Chief Carbone of the Duxbury Police.
Chief Michael Carbone, Duxbury Police Department. As we continue to investigate this painful incident, I'd like to thank the Massachusetts State Police, the District Attorney's Office, and the Duxbury Fire Department for their help, and the many other surrounding agencies for their support and their offering of resources. The Duxbury Police Detectives, along with the State Police Detectives, have been working nonstop and will continue in the days, weeks, months, or whatever it takes to get answers and to hopefully come to justification of or reasoning of what's going on here. Again, I just want to extend my gratitude to the many agencies. Thank you.
Chief.
Chief Rob Reardon, Duxbury Fire Department. On behalf of the entire fire department, our thoughts and prayers are with the victims of this tragic event, their family members, and all the members of our regional public safety community who responded. Tragedies like these are always difficult to comprehend and process. We may be left struggling with many emotions. Please know that all public safety personnel have been offered and will continue to be offered needed support. To all those who responded, we care about you. If you or a colleague are in need of support, please reach out. I also want to thank the citizens of Duxbury and surrounding communities for the extraordinary care and compassion they have shown during this very difficult time.
Thank you.
I don't think we need to hear all these people thank themselves.
Wow. What about all their hard work, dedication?
Wait, well, this guy might be saying something different. He looks choked up.
He does look choked up.
Our community is, of course, reeling from the tragic events of last night. And I want to reemphasize with the district attorney that this is an ongoing investigation. Our thoughts are with the family at this difficult time. and they have our deepest sympathies. Many people have been contacting each of our respective departments about the well-being of our first responders and what people can do to help to support them. Following their response and involvement in the events of last night, the fire, police, and dispatch personnel who were either at the scene or provided support during the incident were relieved of their duties shortly thereafter. The Duxbury Fire and Dispatch Departments engaged the services of their critical incident stress debriefing team, and the Duxbury Police Department received support from the Metropolitan Law Enforcement Council and Massachusetts State Police peer support groups. We offer our sincerest gratitude to these groups for their support.
All right. When you're right, you're right. I mean,
Right.
when you're right, you're right. All right.
All right,
So
I want to hear about like what Davey's talking about. That's what I want to hear about. All these medications she's taken. I see things about like she was tried to get herself inpatient. I mean, you're not just a loving, caring mother one day and a murdering monster the next.
what about
It's just-
Susan Smith? She was a
Susan
murdering.
Smith, I think, is just got out.
She didn't
Or
get
she was-
out. She just had her parole. Her first.
Oh, is that what she
parole.
had?
Yeah. She did
Um,
not get out.
And like I can't remember like what she said, but that's like even different. I mean, obviously it's the same. Like she killed her children, but this is like she slaughtered them with her bare hands. I don't know. It's just
It's different. I was prodding you, but it's 100% different. Susan Smith was a giant piece of shit.
actually
Susan
I
Smith
think
is the one who blamed some black guy in a red car, saying that he carjacked them with the kids in the car. You know, like had people looking for a black guy in a red car for days. Yeah, completely different circumstances. Like understand that. Like no matter what comes out about what was going on with Lindsay Clancy, there are going to be people that don't give a shit. It's exactly what I was talking about with Luigi Mangione today.
no,
when I'm
that can't be
No, I'm
comparable.
talking about mental illness, honey. I'm talking about mental illness. If there's mental, there's just people out there that are not going to give people a pass. They don't care what's going on upstairs. You know, it's like you have to think about mental illness. If you broke your arm, what would you do? You would go to the hospital, get the thing set, and get a cast. You get it treated. People, just because they can't see the injuries to the brain, have a really hard time wrapping their mind around the fact that the brain, which is by far the most important organ in our body, it can absolutely be diseased. So, all right. So the next thing I've got this on 1.25 speed. I don't know. It's an arraignment. I'm not sure why they've got it at 46 minutes, but we're not going to watch 46 minutes, so don't worry about that.
2359 CR 0153 for Commonwealth versus Lindsay Clancy.
Thank you very much. Could I have counsel for the Commonwealth, counsels identify themselves for the record?
Good afternoon, Your Honor. Jennifer Spray from Commonwealth.
Good afternoon, Your Honor. Amanda Falco, Commonwealth.
Could I have counsel for Ms. Clancy identify himself for the record?
Good afternoon, Your Honor. Kevin Reddington. I represent Lindsay Clancy, who is appearing by Zoom, as I understand.
Okay, very good. I can see Ms. Clancy on the Zoom line. In this matter, this arraignment is being conducted at the assent of the parties, with Ms. Clancy participating from the hospital that she is in. This is done to ensure, and it's on Zoom, that the public has as much access as possible to court business. It also ensures any privacy rights of people doing business at the hospital and helps the hospital in dealing with what they need to deal with on a daily basis. And both sides have assented to doing the arraignment this way. At this point in time, there is a court staff that is at the hospital. Mr. Jackson, can you hear me? And is Ms. Clancy in a position that the two of you can hear me?
Yes, Your Honor.
Yes, Your Honor.
Thank you very much. Ms. Clancy, at any point in time, if you needed to speak to your attorney, you can indicate that you'd like to speak to your attorney, and we can make arrangements to go off record where you would be able to have a private call with your attorney if that became necessary. Very good. I will first here, I've had a chance to review the court filing in its entirety. I have had a chance, there were documentation from a treating surgeon, as well as some letters that were also submitted to the court. I have had a chance to review all of those documents. Commonwealth, I'll hear from you first.
Your Honor, I apologize, excuse me, counsel. Your Honor, I would request, much like we do many times with an identification issue, that rather than have the Zoom focus directly on her, you know she can hear, you know that she's able to understand what's going on based on the response by the court officer. I'd ask if they could just avert the camera somewhat so that she's not constantly center of that.
No, I don't have a problem. Given the arrangements, I think it's fine the way it is. Okay, thank you.
Your Honor, shall I arraign this young lady?
Yes, you may proceed with arraignment, Mr. Clark.
Ms. Clancy, on docket 2359 CR 153, the court has a complaint charging you under 265 section 1, count 1 murder, juvenile 1. Count 2, 265 section 1 murder, juvenile 2. Count 3, 265 15D big A, strangulation or suffocation, juvenile 1. Count 4, 265 15D big A, strangulation, suffocation, juvenile 2. Count 5, 265 15D big A, strangulation or suffocation, juvenile 3. Count 6, 265 15A big A, assault and battery, dangerous weapon, two-way exercise rope, juvenile 1. Count 7, assault and battery, 265 15A with a dangerous weapon, two-wit exercise rope, juvenile 2. And count 8, 265 15A, assault and battery, dangerous weapon, exercise rope, two-wit, juvenile 3. Ma'am, a plea of not guilty will be entered. Please be advised while this case is pending, any violation of state, federal, local law may result in bail being revoked and be held without bail.
Commonwealth, I'll hear from you first.
Thank you, Your Honor. The Commonwealth is requesting that the defendant be held without bail based on the facts of the case, the strength of the Commonwealth's case, and the potential penalty. On Friday, January 27, 2023, using an erasable whiteboard because she was still temporarily intubated, one of the first questions that Lindsay Clancy asked was, do I need an attorney? She knew that she had murdered her children, and she had the clarity, focus, and mental acumen to focus on protecting her own rights and interests. The following is a summary of the events that led to the murders of Cora Clancy, Dawson Clancy, and Callan Clancy. On the morning of Tuesday, January 24th, 2023, the defendant took her 5-year-old daughter, Cora, to the pediatrician's for an appointment. She interacted with a receptionist, nursing staff, and a doctor. There were apparently no issues with the defendant's demeanor or behavior as she completed the appointment and was allowed to leave with Cora without any issues or concerns. When she returned home, she went outside with Cora and her 3-year-old son, Dawson, to play in the snow. They built a snowman. The defendant sent photos to her mother and to the defendant, straight that to her husband. She texted with them. Nothing in the text was out of the ordinary or any sign of any distress or trouble. Back inside later that day at 4:02 p.m., the defendant searched on her phone kids' Miralax.
Yet she strangled her 3 children. Like, is that law? Like, when prosecutors talk about shit that people are doing that makes it seem like they're normal, and you have a fact pattern like this that belies any sense of normalcy, it just blows my mind. It just blows my mind. Now, I'm not sitting here saying that she shouldn't be convicted on this thing because I haven't heard all the facts. If I hear that her mind was diseased and that they were improperly medicating her and just like that she was put in this, I mean, how do 7 different scripts interact with one another? I mean, I've never even heard of something like that.
And I mean, I assume they're going to say that she was, intentionally asked him to go pick up the food, checked how long it would take to get there. So she knew how much time she had to do the deeds, showing planning and rational thought. But,
Oh, she's definitely going to say that. I mean, it's all that. I mean, it was the same thing that
She then searched that takeout 3V via her cell phone at 4:13 p.m. Immediately after doing that, she used Apple Maps on her phone to determine how long it would take someone to drive from her home in Duxbury to 3V restaurant in Plymouth. So she would know how long someone would be gone if they ran that errand. She next went on the CVS website at 4:47 p.m. and then called CVS on Summer Street in Kingston. She spoke to the manager of CVS and asked if they had the kids' Miralax. The manager told her no, but they had other similar medications. According to the manager of CVS, her voice did not sound slurred or impaired in any way. She had no trouble understanding the defendant, and it was a perfectly normal conversation. At 4:53 p.m., the defendant texted her husband, who was working in his home office in their basement. She texted, "Any chance you want to do takeout from 3V? I didn't cook anything. It's been a long day." This was an unusual request, as when the family ordered takeout, they'd usually go somewhere closer to home, but it was a place that they had been in the past. Patrick Clancy texted back yes, and then the defendant asked him to check the menu. At 5:06 p.m., the husband texted the defendant asking what she was going to get. She responded, a Mediterranean power bowl. She spelled it correctly, and it was something that was on the menu. He then told her that he wanted the scallop and pork belly risotto. At 5:10 p.m., the defendant called 3V Restaurant to place the order. She got the order correct. She gave the correct name for pickup, Patrick. The hostess who took the call said there was nothing out of the ordinary about this call. She was able to understand the defendant, that her voice was not slurred or impaired in any way. At 5:15 p.m., Patrick Clancy headed out the door to run these errands at the defendant's request. As he left, she texted him Pedialyte liquid stool softener. Surveillance footage shows Mr. Clancy at CVS on Summer Street in Kingston at 5:32 p.m. He goes to the medication aisle, the children's medication aisle. Phone records show that he called the defendant at 5:33 p.m. and she did not answer the phone. She then calls him back at 5:34 p.m. and the call lasted 14 seconds. He's there at the store unsure of which medication to get, and she tells him exactly what she wants. He had no issues communicating with her. It was a completely normal call, although he did mention that she seemed like she was in the middle of something. He is on surveillance footage during this time, exiting that aisle and appeared to be using his phone. He then heads to the register, makes his purchase, and leaves the store at 5:37 p.m. He's next seen on footage at 3V Restaurant at 5:54 p.m. He picks up the food and he's out of there within a minute. When he arrives home, the first thing he noticed was the silence. He did not see or hear the defendant or the children. He actually called her cell phone at 6:09 p.m. looking for them, and she did not answer. He went to their bedroom on the second floor and the door was locked. He was able to open it, and when he looked inside, he saw blood on the floor in front of a full-length mirror and the window open. He immediately runs downstairs and into the backyard, where he finds the defendant laying on the ground. She appeared to have cuts on her wrists and neck, but he stated to 911 that those wounds were no longer bleeding. She was conscious. He called 911. During this time, he asked the defendant, "What did you do?" She responded to him, "I tried to kill myself and jumped out the window." During the 911 call, Patrick can be heard asking the defendant, "Where are the kids?" He later told police that she replied, "In the basement." So immediately after this happened, she knew what she had done and she knew where the kids were. When EMS arrived, he asked them to stay with her so he could go find his kids. The 911 call kept going. Patrick can be heard on the 911 call entering the home and heading to the basement. At one point, he calls out, "Guys." He can then be heard screaming in agony and shock as he found his children. His screams seem to get louder and more agonized as the time passes. Cora and Callan were on the floor in the den area of the finished basement, which is to the left when you walk down the stairs, while Dawson was alone on the floor in his father's home office, which is to the right when you go down the stairs. Each child still had the exercise band that was used to strangle them tied around their necks when their father found them. Dawson and Callan were face down on the floor. Cora was on her side with her torso turned towards the floor. He removed the bands and begged them to breathe. He continued to scream uncontrollably and screamed for officers to come to the basement. The dispatchers are hearing this and they send help down to the basement. And when they encounter Patrick, he yells out, "She killed the kids." The police rushed the children to ambulances that brought them to the hospital. And unfortunately, Cora and Dawson were declared dead at the hospital. Callan was med-flighted to Boston Children's Hospital. Medical staff was able to restart his pulse, but not his brain activity. He was placed on life support for several days before passing away. The defendant was transported to South Shore Hospital and then to a Boston area hospital where she remains. She sustained several broken bones in her back and her rib cage. The police were able to find several notebooks in the defendant's home pursuant to a search warrant, and also notes on her phone that were similar to journal entries. In the months, weeks, and days preceding January 24th, 2023, the defendant meticulously detailed her daily activities, her children's lives, her mental state, and her medication use. Her writing was clear, precise, and articulate. She never indicated that she was hallucinating, delusional, or had disordered thoughts or speech. In all of her writing, she appears to know who she is, where she is, the date, and with whom she's interacted. She wrote a note on her phone the day before killing the children, stating that she had, quote, "a touch of postpartum anxiety," end quote, around returning to work. She wrote that her psychiatrist had prescribed medication to help her. The defendant was initially diagnosed, according to her husband, with generalized anxiety disorder. She was then evaluated at the Women and Infant Center for Women's Behavioral Health in Providence, Rhode Island on December 20th, 2022. There, after an evaluation, she was told in the presence of her husband by psychiatrists that she did not have postpartum depression and that she had no symptoms of postpartum depression. She wrote in her journal that at times she had suicidal ideation in December of 2022, and she also told her husband that she had suicidal thoughts and on one occasion had thoughts of harming her children. But she did not write or voice those thoughts after a stay at McLean Hospital. When she had those thoughts, She consulted with a psychiatrist and with her husband, and then she committed herself to McLean Hospital on January 1st, 2023. She was discharged by the hospital on January 5th, 2023. And the hospital did not file any paperwork at that time attempting to have her committed as a danger to herself or others. She also kept meticulous and detailed daily medication logs in a diary that she wrote. She detailed that she had difficulties with each of the medications that were prescribed to her. And when she had issues with those medications, she detailed how her doctor had her stop that medication or wean off of it and then try something else. They were trying different medications to see what would work for her, what would benefit her. According to her husband, she was never on more than 4 to 5 medications at one time. And at the time of the murder, she was taking only 3 medications. And he said to the police that she always took the medications as prescribed. After her stay at McLean, the defendant appeared to be getting better, according to her husband. She slept well, interacted with friends and family. She went out with her kids and husband to places like the Kingsbury Club in Duxbury, the Charlie Horse Restaurant, the Museum of Science in Boston, the Cape Codder down the Cape, interacting with her family and the public without any apparent difficulties. She even stayed alone with the children on several occasions without any issues in January of 2023. Her husband asked her in mid-January, "Are you still having suicidal thoughts?" And she said no. The defendant's parents visited the family the weekend of January 21st, 2023. They interacted with the defendant in person. The defendant was able to run errands while her mom watched the children. She texted back and forth with her mother, and there was nothing out of the ordinary about these text messages. In fact, the defendant texted her mother on January 22nd, 2023 to ask how her ride home went. During this conversation, the defendant's mother wrote, quote, "Enjoyed seeing everyone this weekend. Nice to see you doing better," end quote. On the night of the killings, Patrick Clancy was interviewed by the police at Beth Israel Deaconess Plymouth Hospital. He told the police that the defendant was having one of her best days. She was smiling and happy, and there was no indication that she was going to harm the kids. No one at all described her as acting like a zombie in the days leading up to the murder or on the day of the murders themselves. On February 5th, 2023, this past Sunday at 1:35 p.m., while sitting with Dr. Paul Zeisel, the psychologist hired by defense counsel to evaluate her mental state, the defendant used Dr. Zeisel's cell phone to call her husband. She left a voicemail stating that she loved him. Yesterday, on February 6, 2023, at 10:09 a.m., she again used Dr. Zeisel's cell phone to call her husband. This time he answered, and during this call, the defendant stated that after he left the house that night, she killed the kids because she heard a voice and had, quote, "a moment of psychosis," end quote. He asked her what voices she heard, and she said she heard a man's voice telling her to kill the kids and kill herself because it was her last chance. Patrick Clancy told the police the defendant had never heard voices before. He also told the police the defendant had never used the word psychosis to him before. The first time she used that word psychosis was when she was with a doctor hired by defense counsel and using his cell phone. The defendant actually wrote a note on her phone on October 25th, approximately 3 months before this happened, October 25th, 2022. She wrote, quote, "I think I sort of resent my other children because they prevent me from treating Cal like my first baby. And I know that's not fair to them. I know that. I was feeling so depressed last evening when Cora and Dawson came home from school. I know it runs off on them, so we had a pretty rough evening. I want to feel love and connection with all of my kids." She then wrote that she wants to have more kids eventually. The children were killed by ligature strangulation. Ligature strangulation causes the victim to become unconscious anywhere from 10 seconds up to a minute. The more the victim struggles, the longer it takes. After the victim is unconscious, the ligature must be held in place with force, squeezing the neck for up to an additional 4 to 5 minutes to cause death. Therefore, she had to strangle each of them to unconsciousness and then make sure the bands were squeezing their little necks for several minutes. She could have changed her mind at any point during that time and removed those bands from their necks, and she did not. The defendant did not take advantage of the situation when her husband left the home that night. She created the situation, and she used Apple Maps to make sure she would have enough time to strangle each child before her husband returned from where she had sent him. The defendant is a danger to herself and others. She planned these murders, gave herself the time and privacy needed to commit the murders, and then she strangled each child in the place where they should have felt the safest, at home with their mom. She did so with deliberate premeditation and extreme atrocity and cruelty. And to supplement what the defense counsel has provided, I have a statement of Bill I need to file with the court. And thank you, Honor.
Thank you very much. Attorney Reddington.
Thank you very much, Your Honor. Your Honor, my request is that the court not enter what I would suggest is an inhumane order, ordering this woman to be incarcerated. We all know, as people that work in the system, that jails and prisons are woefully deficient in medical care of the most basic type. We all know that this is an individual, as Your Honor knows from Dr. Ricard's letter, who is in dire medical condition. We all know that this woman is, as counsel concedes apparently, a danger to herself. I question whether she would ever make it to a trial. She's suicidal. She's extremely emotional. However, she's unable and has been unable to express any happiness or sadness or cry. And in fact, sometime about a month or two ago, she made the comment, I just wish that I could feel something. Now, our society fails miserably in treating women with postpartum depression or even postpartum psychosis. It's medicate, medicate, medicate. Throw the pills at you and then see how it works. If it doesn't work, increase the dose or decrease the dose. Then end up trying another combination of medications. We're talking a relatively short period of time from when that baby was born in October up until January, when this incident occurred, Your Honor, that she was on such significant dosage of medication. Your Honor knows that Cora was born in 2017. It was a very uneventful, normal pregnancy and delivery. No issues afterwards as far as anxiety. Dawson was born in 2018. Again, it was a normal birth. She had no significant issues as far as anxiety. She did have to have stitches and she was sore, and that was about it. Then, of course, Callan was born. When Callan was born, she ended up becoming depressed and suffered from significant anxiety, as a result of which she consulted with a number of doctors. A number of doctors indicated that she would be able to sleep, she would be able to feel, she would be able to emote once these medications kicked in. And again, as I say, our medical and our society completely abandons women with this condition. It's easy to say, come on, you have a healthy baby. You have a wonderful husband. You're able to take care of your kids in your home. You're lucky. Take the pills, you'll be okay. Well, they put her on a number of medications. They put her on Prozac, which Your Honor is well aware, is known as SSRI, selective serotonin reuptake inhibitor. Your Honor knows that along with some of these medications, they have the black box warning from the FDA, may cause suicidal ideation, may cause homicidal ideation. She was on Ativan. She was on Benadryl. And then she ended up being told, okay, because she was complaining about the effects of the Prozac, they said, stop the Prozac, we'll find something else. They put her on Remeron. Then they added on Seroquel. And Your Honor, I attached from David Benjamin, the toxicologist, some papers with the submission, and Your Honor can see the side effects that this Seroquel causes. She was having bad thoughts. She was having worsening depression. Her husband suffered through that phase. Her parents were well aware of the fact that she was suffering from this depression and depressive phase. She wasn't sleeping. She ended up, at some point, Your Honor, December 31st, she was on Seroquel. They told her then the Valium would be stopped. She was a shell of herself, no personality, and went to the doctor again. The doctor again prescribes the Seroquel, and then they took her off the Seroquel. And then she went to the doctor, and at that point, they prescribed Trazodone, Ativan, amitriptyline, right up to the very end, when she was so bad that she voluntarily turned herself in, if you will, to the McLean Hospital. We know that that's a psychiatric hospital. She was at the McLean Hospital for a period of about 5 days. While at the McLean Hospital, they basically tried to get her off the Seroquel. She wanted to get off the benzodiazepines. She felt that she was being addicted to the benzodiazepines. She then ends up on Trazodone, Ativan. Her mood was terrible after she got out of McLean Hospital. She still had the suicidal thoughts. As the government has indicated, she even told her husband that she had suicidal thoughts. You think this is something that she's planning to kill these 3 kids by going and getting a menu, going on to Google Maps or whatever it is, and finding out the distance? When she tells her husband she's having suicidal thoughts, probably a month prior, thoughts of hurting the children, they go to the doctor again, and she's on the medications, on and off, on and on. This is a significant issue between the postpartum depression as well as possibility of postpartum psychosis that is pretty much ignored. But nevertheless, with the overlay of the SSRIs and the history, and Your Honor has some emails and things that people would reach out to me from all over the world, indicating that their daughter had the same problem, that they had the same problem. Your Honor is well aware that many times when people are on Prozac or on SSRIs, workplace violence, homicides, family homicides. This is clearly a tragic, which is a word that's used too much in the criminal justice system, but this really is a tragedy in this case. So we have, obviously, I would suggest, a very good defense for this young woman. She's 32 years of age, Your Honor. She met her husband. He was the love of her life. They got married. Wonderful young couple. And as counsel noted, she always wanted to have kids, always wanted to have babies. She's a nurse. She went to be a midwife because she wanted to help other women that would be in having babies, but didn't want to have all the medications. She was not a big medication person. Your Honor saw, I think there's probably close to 50 letters that have been submitted to you, and I know you read every one of them. The incredible outpouring of support.
Have I told y'all how much I love defense attorneys? I love defense attorneys. I love them.
By other nurses that work at Mass General Hospital. The fact that these women have a vigil, that they write the letters to this court imploring you to understand that you sentence, as far as bail issue, the woman before you, who was a beautiful person, who was thoroughly destroyed by these medications. That's for another day, obviously. A bail issue, bail argument. Your Honor is well aware under Cromwell versus Vasquez at 481 Mass 750, Supreme Judicial Court indicated that this court, or the court, has vested in sound discretion of the bail judge. And the main considerations would be obviously the usual bail considerations: nature and circumstance of the offense, likelihood of success on the defense, roots in the community, and of course, as the in Vasquez case, as well as Cromwell versus Herring, 489 Mass 569, defendant's risk of flight. So now you have a situation, Your Honor, where this woman has incredible support, as you saw, letters from Foxborough that were signed by about 15 women, letters from her family, friends, letters from people she's known since the 6th grade that have stayed in touch with her. One thing that's a theme that is readily apparent is that Lindsay loved her children, that she would always, one of the letters said, she would always rub her belly, rub her belly. She had pictures of her pregnant standing next to Patrick, hanging on the wall. I was in the house. The house is absolutely loaded with indicia of love for those kids. Photographs on the wall, little drawings, all sorts of games, toys, playpens, bassinets in the living room, in the dining room, the kitchen loaded with toys. Virtually the entire house, including their master bedroom. Toys, things for the kids. This is not a situation, Your Honor, that was planned by any means. This is a situation that clearly was a product of mental illness. Now, under the Vasquez case, one of the issues, as I said, is whether or not there's a risk of flight. Now, I did submit to Your Honor a letter that was written by her physician, her attending surgeon, Nakul Rekha. This doctor was in surgery until 8:30 at night and actually took the time to write this letter for you to review. And I just want to make note that he makes reference to the fact that she is now in her 12th day of hospitalization following admission on January 25 after a 20-foot fall. She suffered, unlike when the government Friday was saying that she can move her legs and she's getting better, she's okay. No, she's not okay at all. He indicates that she suffered several severe spine fractures, including spinal cord transection. You know what that means. At the level of T5, T6. As you know, she had surgery for this from the orthopedic spine surgical service who performed a decompression infusion. Unfortunately, she is not expected to recover meaningful function at this point below that level of the spinal cord, which makes her a paraplegic, unable to move her legs or feel sensation from below her, he refers to umbilicus or belly button. He says she has no function below this level. Additionally, less active issues include rib fractures in the chest, both sides, cervical spine fractures, necessitate the wearing of a collar around her neck due to the cervical spine fractures. She's paralyzed. The doctor indicates that she needs significant medical treatment. Doctor recommends that she would be discharged to Spalding Rehab. Now, you know that we have Spalding Rehab. You know that we have the Worcester Hospital. This court is vested under Vasquez with your authority to have this woman not held on bail. Perhaps put a GPS on her, I guess, if someone's concerned that she's going to miraculously recover, which isn't going to happen. As Your Honor knows, being a paraplegic, paralyzed, she can't move, can't get off the bed, she can't walk, she can't even go to the bathroom. She has to have 24/7 medical care. Her emotional state is so bad that there is a significant fear of suicide. She has to have someone sit in the room 24/7 to watch her. They don't talk to her. They're not, chatting it up. They just sit there and watch out of that concern that she would commit suicide. So you have a paraplegic who can't walk, who is definitely a danger to herself, and the government wants to put her in where? Framingham State Prison, Plymouth House of Correction. There's no way that any humane person would do that, especially within the structure of our criminal justice system, where a person is presumed innocent. And I'm not suggesting the facts that the government has read, but she has good defense. She's got a darn good defense for this case, because that's what happened. And I just want to share with you, Your Honor, one of the things that's interesting. When I was in the house, I came across a drawer that had a bunch of pill bottles in it. And I called the DA and I said, I got these pill bottles, and made arrangements. I'm going to be giving them to them. And it's all the Prozac, the Trazodone, and all that stuff. But inside the drawer was this little vase. And I didn't know what it was. Just looked like a little vase to me. And my wife said to me, "Oh, that looks like a wish vase." I said, "What's a wish vase?" She said, "When people write down little wishes and they put little pieces of paper and they put them inside the vase." And there are literally dozens of these little pieces of paper that talk about Lindsay's wish for happiness and health for her children, that she could get pregnant again, that she would be able to be with her children, little Callan, Dawson, Cora, that they would be happy, healthy, and successful. This is not a woman, Your Honor, that had any reason to harm those innocent children. My request, Your Honor, is that the court would put her on a GPS if you feel that's required, and let the doctors continue to treat her. Let her go to Spalding Rehab. She will sign a waiver that allows probation at any time to speak with her treating physicians or social worker, find out how she's doing. Does it look as though she's getting close to regaining the ability to walk, which she isn't, but nevertheless, they would be able to do that. And then the government would be notified, and they can come back in here again and try to hold her without bail. My request would then be to Worcester for the emotional and the mental illness aspect. I don't think that it's fair or just or consistent with our duties to each other as human beings to put her in jail. I'm asking that she be allowed to continue with her medical treatment. Your Honor.
I would hope he would do that.
Your Honor, if I may, I did look into medical treatment if she's held. We were under the impression we had received information before that she could move her legs, but then we learned updated medical information that she, for the time being, is paralyzed from the waist down. If she is held, she could go to the Shattuck Hospital. If Shattuck does not have what she needs, she can be sent to another facility, and the corrections officers would go with her there. Shattuck would actually work with her, the doctors at the hospital she's currently at, to determine the best course of treatment. And if whatever she needs, she's going to get. But as defense counsel said, she is a danger to herself and, from the Commonwealth's perspective, others. And just because she is paralyzed does not mean she's not a flight risk. She will be in a wheelchair eventually, and she can be driven somewhere. She can be flown somewhere. It does not mean that she will never be able to leave this area.
Just would like to say that yeah, sorry.
Go ahead.
Thank you. I have been, unfortunately, in the Shattuck Hospital. To suggest that she can get, quote, what she needs from the Shattuck Hospital is absolutely not true. The care that she's receiving at the hospital she's at now and the care that she would be receiving at the Spalding Rehab are light years ahead of the dismal, dank conditions of the Shattuck Hospital that we put our prisoners in. It's like something out of Iran, and that's not fair or correct.
Thank you both. Both of you, all of you who were there before me, that will be litigating this case are all very well respected. And I'm sure at some point in time in Superior Court, this case will be tried in a very professional and very well by both sides. As counsel stated in Commonwealth v. Vasquez, the Supreme Judicial Court addressed the issue of bail in first-degree murder cases, and Justice Lowy issued a detailed decision about the issues in these types of cases. The court found that a defendant charged with first-degree murder has no right to bail, but may be admitted to bail in the discretion of the judge. The court ruled that a judge should consider the nature and circumstances of the offense and weigh the defendant's risk of flight in light of the strength or weaknesses of the Commonwealth's case and the potential penalty of a sentence to life in prison. The court further noted that appropriate considerations for a judge would include the defendant's family ties, financial resources, length of residence in the community, character, mental condition, record of conviction, appearances at court proceedings, or any previous flight to avoid prosecution or failure to appear at any court proceeding. It is important to note that the purpose of bail is not to impose punishment. The court has conducted a careful review of the details of the case and the defendant's history. The court's reviewed the filings that have been made, as well as letters submitted by counsel for the defendant and the update that was received from her attending trauma surgeon. The factual allegations in this case are both horrific and tragic. The potential penalty faced by the defendant, if convicted, is severe. The defendant has no criminal history. She does not even have a driving record. There is no evidence of any history of any abusive behavior by the defendant. The defendant was raised in New England and has extensive ties to the local area. She has an extremely supportive family. She had worked for several years in a local hospital, and a number of coworkers have written letters in support of the defendant and her character. She's described in these letters as an exemplary worker, colleague, and friend. In the letter submitted by her attending trauma surgeon, she has extensive injuries that will require long-term inpatient rehabilitation. Weighing what the doctor has written and the facts from the defendant's current condition, the court finds that there is minimal risk of flight given the defendant's circumstances. The court is going to make the following order on bail. The defendant shall remain in her current hospital until medically cleared to be moved to a new facility. As a condition of bail, the defendant is ordered not to leave the hospital until discharged to a new facility. The defendant shall provide notice to probation 48 hours in advance of any transfer to a different facility. Based on the letter of the doctor, it would appear likely that she would be sent from the hospital setting to a 24/7 rehabilitation facility, like the Spalding Rehab. As a condition of bail, if sent to a 24/7 rehabilitation facility, she is ordered to remain in that facility, with the exception of if she needed to be transported to a different medical facility or a hospital for an additional MRI or something like that. The defendant shall continue to receive mental health treatment while hospitalized and sign releases for probation to monitor compliance with counseling. In the event that the defendant were to complete the services at a 24/7 rehab and complete that care, the court would hold a further hearing as to whether or not the defendant were in need of further mental health treatment that would need to be done in an inpatient setting, or whether or not the defendant's mental health care could be provided in a residential setting. The court would direct court clinician, court doctor to consult with the defendant's mental health providers to conduct this evaluation at the appropriate time in the future. If the defendant were in a position that she was going to be discharged to a residential setting, both sides would have the opportunity to be heard further. Any discharge in a residential setting, the defendant would be subject to home confinement with appropriate electronic monitoring to monitor home detention. There would be exclusions that would be available if the defendant needed to attend medical or rehabilitation appointments, counseling sessions, or religious worship sessions. The court would have probation visit any proposed residential setting prior to the defendant being discharged to that type of a setting to ensure that such setting was appropriate and safe. The defendant is ordered to surrender her passport to probation. In the event that the defendant does not have a passport, she is prohibited from applying for a passport. The court is not going to set any monetary bail at this time.
Your Honor, would the court order that any such residential setting be in Massachusetts? I don't think we could do monitoring outside of the state.
If we get to that point, you may make that request. If it becomes an issue, we can deal with that. We clearly have the ability in Massachusetts to appropriately monitor. If for some reason, I know that there are relatives that live in Connecticut, if something like that were being requested, obviously the court would need to make sure that appropriate monitoring were in place, but both sides would have an opportunity to be heard regarding that request. The next step in this matter would be to schedule a probable cause hearing. Is there a date that the parties would like to suggest for that purpose?
We don't need to know when they come back.
I agree, hon. I agree.
Well, I have only got like 10 minutes, but I like applaud that judge. He did what was appropriate. He did what was right, despite, possibly public and pressure from the district attorney or state's attorney. I can't remember what they have there in Massachusetts.
Yeah, no, I agree completely. He ruled the right way. I mean, you want a judge that rules using his mind as opposed to his emotions. And he clearly did that. I mean, clearly her situation physically, the concept that she is a flight risk was absurd. I can't even believe and I get it. I get it from prosecutors. They're tasked. They have a job to do. They have bosses. They've got, her boss has all kinds of people in his ears, I'm sure, or her ears, whatever the case may be. And, they come in and they say and do the things that they say and they do. That's why I'm saying that's why I love defense attorneys, because, you don't have somebody up there representing what the facts are, what was going on with this woman. We're living in a much different world.
This
So
case is going to be a thing because
I'm telling you, I
you've got a lot
am,
of men judges, men, district attorneys that like can't even comprehend postpartum depression. Like this is something that
I
is
would have
unlike.
no idea what it is. None. I mean, you could tell me. I mean, fortunately, at least as far as I know, you didn't suffer from any
No.
postpartum depression, but and you had 4 kids. But I wouldn't even begin to know. I couldn't even begin to know. I could read some shit in a book, but that doesn't tell me a goddamn thing about what it's like to experience it.
Right.
You know what I mean? It's like I couldn't know.
Right.
I'm
But
telling you, babe. I'm like right now, I already feel like I want to fly out for this trial. Like this trial, I think is going to be exceptionally important. Like it just like in a general sense, like I really do.
in
And
a
I
time when women are losing all their other rights, I mean,
and I just and it's like you've got this backdrop of the horrific nature of the crimes. It's like it's truly putting the system to the test.
yeah.
To see if there's any circumstance under which people can allow their minds to get to a place that people cannot be held criminally liable, no matter how horrific the crimes are.
But it's the definition of insanity. That's the legal definition of insanity is at odds with like real life.
I
It just
know.
is.
I know it. And it's like when you're trying to, and I don't know what they use in Mass. I don't
I know.
know.
I gotta look.
I don't know if it's McNaughton or a version of it. But we got to pull up the statute, because it's difficult. Like if you have the, cannot tell right from wrong, you've got this, you have issues where it's just, oh, well, she Googled a restaurant. She Googled how long it would take, it's like
All right,
this.
so they do follow the defendant is considered to lack criminal responsibility if they're unable to understand the wrongfulness of their actions or conform their behavior to the law due to mental disease or defect. You also have to define mental disease and defect, but
Right. All right. So what you pretty much have to bounce? Is that?
I mean,
what
I've
we're
got
gonna do?
about 5 more minutes, but I might as well split now, I guess.
All right. I'm going to go to, so today it was up in court, which was why it was on Dizzy and Tracy's radar. I hadn't even heard of the case.
I'm gonna listen while I listen to you guys while I drive.
Okay.
I'll text you because I might stop and get food for Scout and see if you want anything.
Okay.
Bye.
Love you. Bye.
Love you.
All right. So before we do that, before we jump into today's hearing, there was another hearing that's about a half an hour long. I didn't get an opportunity to watch it beforehand. Dizzy sent it to me. I'm not sure what it was. It sounds like the state was popping off pretty hot there. And it's about a half an hour long. I'm going to skip that one. We're going to go to today's hearing. Before we do that, there were a couple things filed, one by the state and one by the defense. And Dizzy, can you throw it in chat? When is this set for trial, or has trial been set yet? Do we know? So this was filed on my birthday, December 13th, by the defense. And this is defendant's notice of lack of criminal responsibility. Now comes the defendant, Lindsay Clancy, in the above captioned matter pursuant to Rule 14BB, big B. That statements of the defendant as to her mental condition will be relied upon by the defendant's expert witnesses, and the defendant does intend to present to the court a defense of lack of criminal responsibility. And in response, on December 13th, the state filed a motion for a trial date. Now comes the Commonwealth and respectfully requests a trial date in this matter in September of 2025 as reasons wherefore. The Commonwealth states that the date of the offense was January 24, 2023, and the case was arraigned in Superior Court on October 26 of 2023. While DNA testing results and reports from experts are outstanding, it is reasonably believed that this discovery will be complete well in advance of September of 2025. All right. So that leads us up to the hearing that took place today, which we are going to listen to right now. All right. Let's go.
Commonwealth versus Lindsay Clancy. Ms. Clancy's appearance has been waived for today. She is represented by Attorney Kevin Reddington, and the Commonwealth is represented by Assistant District Attorney Kevin Duxbury.
Hi, counsel, good afternoon.
Good afternoon, Your Honor.
All right, Ms. Reddington, good afternoon. All right, so this matter is on really for status and scheduling discussions. So I think first, we've got the defendant has filed their notice regarding mental health defense, and here it is, lack of criminal responsibility. And I know the Commonwealth had filed a motion regarding trial date. And so why don't we first discuss some of the scheduling issues that get triggered under Rule 14 in regards to the notice for lack of criminal responsibility.
Your Honor, if I may, the Commonwealth, our opinion is that the notice is insufficient under the rule. It's supposed to have the names and addresses of the expert witnesses, as well as whether or not those experts will rely on the statements of the defendant. So we're asking for a supplement to the notice with that information.
I believe on the notice, I did indicate that there would be, as far as Blaisdell is concerned, that they would be relying on statements of the defendant. I always supplement the notice by giving the names and addresses of the anticipated witnesses that I would be calling.
Well, I think you're both kind of correct. And so my thought would be, does it make sense to schedule a date by which time the defendant will identify who they anticipate?
Sure.
Because obviously that triggers a lot of other discovery or research in regards to that. So is there a date, Mr. Rank, that you think you could supplement that notice?
Sure. And that would be here?
I think we could just have an out of court
Okay,
filing.
sure. I can file that, say, Friday, January 24th, if that works.
Commonwealth?
That's fine.
Okay. Well, January 24th, defendant will supplement their notice with the names and address of the expert witnesses they expect to call. The notice does say that the defendant tends to rely upon statements of the defendant. All right. Now, if the parties talked or Commonwealth in regards to, I guess, the positions, whether or not what you receive would trigger the request in regards to the examination?
Yes, based on the original filing that they would be relying on statements of the defendant, we will be filing a motion to request access to the defendant for an evaluation.
All right. Well, I think so in regards to scheduling, because we're also going to have to schedule that hearing on that Rule 17. I don't know if Mr. Rankin, you saw that. It was just filed today.
I have no objection to that.
All right. So we should probably mark that up though. Just so how much time, Commonwealth, do you think you need in order to file the motion regarding the examination?
I think I could have that filed by January 24th as well.
All right. So do we want to, so we'll pick that date for the supplementation as well as the filing and regarding the examination. And then, well, I don't want to jump ahead, so we'll get to that. All right, and so the motion, you anticipate that the motion will identify suggested examiner?
Yes.
Okay, all right, so I'll hold off on any of that, and that'll give the defense an opportunity to review that as well. So got that.
I would be filing a motion. I don't know if the government has sense of it. I wouldn't have to, for permission to videotape and audio tape the Blaisdell examination.
Well, why don't we do this? I've had this come up before, and I know that certain experts have a problem with it. Some certain experts don't. So why don't you file, if you want to file that, then we can address that on the 24th as well. And that'll give the Commonwealth an opportunity to maybe consult with whoever it is that they're going to suggest be the examiner, and kind of at least know what their position is. And then we can have an argument in regards to that. I'm not saying I'll go either way, but at least we'll have all the information. We can hear that. All right. Now, do the parties want to argue this Rule 17 motion now?
I think we need to give notice to the record holder, and I think they will probably object to the motion.
Yeah, that's what I'm assuming. Well, we have that date. Does that January 24th date work, or do you think we need to accelerate that motion somewhat?
I will be on trial the 13th through the 24th, so if perhaps we could have something the first week of February.
So if you're on trial for the 24th.
January 13th through the 24th.
Right. But so we just scheduled a bunch of things for January 24th.
I thought that was our out of court filing date. That's an out of court filing date.
Well, I'm just saying that, well, in regards to the motion, say for the, to videotape the examiner, my thought was to have those dates. So those dates don't work for you?
I apologize, Your Honor. I thought that that was going to be an out of date filing, out of court filing.
The original one, and then I just kind of, without telling you, I can't transfer it into in court. So I understand the confusion. So do you want to pick a later date in regards to that, maybe a week or so after?
Yep.
That's fine.
Sorry about that.
How about Friday, February 7th?
That's fine.
Okay, all right. So why don't we do it this way? We'll keep those dates for filing, January 24th. Then we will keep that February 7th date for hearing on those motions. And that will be up in Brockton, because I'm going to be up, I'll be in the, so it'll be in the third session. So we've got that date. That'll be for the Rule 17 and any of the other motions that are going to be filed.
Your Honor, would I be able to have her appear by Zoom and that for purposes of the hearing, or would you require it in person?
Commonwealth?
No preference, Your
Yeah,
Honor.
I don't have a problem in regards to having her appear by Zoom at that point. Just make sure that you kind of let the clerk's office know a couple of days beforehand so they can set that up.
Sure.
And she's still up in
Yes,
Duxbury,
Duxbury, yep.
so she'll have to coordinate with Duxbury as well.
Yep.
So that'd be fine.
Great, thank you.
And then I guess the other discussion really is in regards to a trial date. I know the Commonwealth had called and filed their motion. The parties, the request is in September. Is that going to give parties enough time? I'm not sure I can do it in September, but just that general time frame, is that going to give
We're off a
both
little
parties
bit.
enough?
I'd ask for December if you want September, so
All right.
I already have a matter scheduled in federal court in the beginning of September. Summer's pretty well wiped out, so I'm concerned about preparing for other cases, plus this one here, so I would ask for December.
So Commonwealth, you're seeking a September date?
Yes, I was asking for a September date, but if defense counsel is on trial, obviously that won't work. I can do any date between September and December.
But I just kind of want to make sure, because all three of you know, and I'm familiar with these type cases. I just want to make sure this gives us enough time, give Bailey counsel enough time to get the information, to kind of line up who they need to have here for the trial, and to be prepared. So that's all the reason I was asking. I'm not doubting that, but I just kind of wanted my little checklist in my head that I've gone through it. So, Commonwealth, do you think that would give you enough time, if that's a calendar?
Yes.
See, September, December. Mr. Reddington?
Yes.
Okay. All right. Well, in regards to September, these are more my problems in regards to it. I'm not scheduled to be in the county. I think that this courthouse works well for a case like this. We've done similar cases like this in the past. And so I've got to line up kind of some of the moving parts to have the case tried here. More importantly, that I'll be here. I've got the appellate division, like early October. So if we started in September, I worried that it might kind of bump into that, and that's a problem. So my thought, I looked at the schedule. December 1st, I think, is the, obviously it's the first day of in December. So if we went to that date, that would give us, time to try this case. Colin, how long do you think? And I know this is a tough case to estimate, but
I would say 2 to 3 weeks, including impanelment.
strengthening.
I'd agree with that. Probably 2 weeks for impanelment and a week for trial. It's going to be difficult.
All right, but I mean, I think that window then would work well. So why don't we say at this point, we say December 1st for trial,
Fine.
and then maybe a week or so before that for final trial conference.
Sure.
Could we potentially do a couple weeks, maybe 2 or 3 weeks prior, just because there might be some involved issues that Your Honor might need time with?
I think that's a very good idea. All right. Plus, I think we've got Thanksgiving's probably in there too,
Yes.
and that's I don't want to tie up the parties. So, yeah, maybe 2 weeks or so.
Yep. How about November 17, 18, 19, Monday, Tuesday, Wednesday?
Any day that week is fine.
You want to say the 17th?
Okay.
All right. And for now, just to confuse everybody, I'm going to be in Dedham in a civil session. And why don't, for right now, assume that that's where we can do that. And if counsel wants to have the defendant by Zoom, we could do that. I know that was a difficult courthouse.
Right.
So why don't we do that? And if we change that, I'm able to shift it down here. I'd rather do it down here, but I if there's a problem comes up, I don't want to delay anything. So I know we could do it in Dedham on the 17th. But we'll double check. So for now, it's in Dedham. Okay.
Your Honor, for motions in limine, we'd obviously file them with the clerk's office here, but would you like us to email a copy as well, since you won't be here
Yeah.
via the clerk?
Yeah, I think that'd be helpful. Then they can forward it to me, and then I'll have them. Yeah, the earlier I get them, the better. I think that would be helpful, especially even questions about impanelment, voir dire questions. Obviously there's got to be voir dires for certain witnesses, things like that. So the earlier we know, the better. So, all right. All right. What else? What else do we need to address at this point?
I don't think there's
Come on.
anything else.
Strengthened.
Sure.
Counsel, can I see your sidebar just for a second?
All right. So December trial date. Looks like I'll be spending December in Massachusetts. All right. I'm here for it. All right. So what I think will be helpful, Dizzy put together an amazing, so you guys have been observing it, an amazing case overview for us, which has allowed me to guide you through it. The last thing that I want to take a look at, and I know Olivia had asked specifically about whether or not the notice that was presented by the defense regarding lack of criminal responsibility incorporated the insanity defense. And I think that the best way to go through that with y'all is to read through the actual jury instruction, which goes through what the burdens are and what has to be proven. So let's go through that. I think it'll give you guys an excellent idea of what the burden of proof is going to be in this case, who has the burden, and what that burden entails. So this is a pattern, what they call a pattern jury instruction. So in most cases, pattern instructions are what are read. For our friends that have followed Karen Reed, we know that there was some issues with jury instructions in that case in particular, which I think ultimately still ended up rearing their ugly heads when it came time to rendering a verdict in that case. So as I said then, and as I say it all the time, jury instructions are boring to watch when you're watching a jury instruction conference. However, they are absolutely critical. They are one of, if not the most important thing that is going to the jury. And that includes the facts. I mean, these are the rule book for those jurors when they go back and start deliberating. So they're very, very important. And they are really, really just instrumental in terms of a jury being able to do its job back there. So this is the lack of criminal responsibility instruction, and it states as follows: if the Commonwealth has proved the elements of the offense beyond a reasonable doubt, the Commonwealth must also prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged offense. That is a very important sentence because a lot of people tend to forget about that part of these cases. It matters not what the defendant's state of mind is at the time of trial. And frankly, it matters not what the defendant's state of mind was leading up to the crime. What matters is what the criminals or what the defendant's state of mind was at the time that the crime was committed. Okay. And they're very distinct things. So under the law, a person is not guilty if they lacked criminal responsibility when they committed the offense. This is sometimes referred to as not guilty by reason of insanity. There is no burden on the defendant to prove that they lacked criminal responsibility. The Commonwealth may meet its burden of proving a defendant was criminally responsible for their conduct in either of two ways. The first way is for the Commonwealth to prove beyond a reasonable doubt that the defendant did not suffer from a mental disease or defect at the time of the alleged offense. A mental disease or defect need not fit into a formal medical diagnosis. It is a legal term, not a medical term. It does not, however, include an abnormality that presents itself only by repeated criminal or otherwise antisocial behavior. It is for you to determine from the evidence whether the defendant had a mental disease or defect at the time of the alleged offense. And it cites a case here. And the case says that we have previously indicated that a judge is not required to define a mental disease or defect, but has discretion to provide the instructions that are appropriate to the context. The court, this court has declined to impose any, now this is from Commonwealth v. Fuller. This court has declined to impose any obligation on a trial judge to provide further explanation of the terms in issue here. Our unwillingness to impose a mandatory instruction arises not because of the term mental disease or defect is so clear on its face that such an explanation would be superfluous. The reason may well be the opposite. The subject is so complex and obscure that any general explanatory formula is likely to mislead and confuse. I love that case. I love that case. And I love, this is an excellent jury instruction. So the second way for the Commonwealth to prove a defendant was criminally responsible for their conduct is for the Commonwealth to prove beyond a reasonable doubt that even if the defendant suffered from a mental disease or defect at the time of the alleged offense, the defendant nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of their conduct and to conform their conduct to the requirements of the law. Now, this is going to be the battle. That is going to be the battle right there, because they've got two ways to approach it. The state is obviously going to be using this second way to prove beyond a reasonable doubt, and they're going to be using those facts that we heard in the first hearing we watched. They're going to be using the facts that she seemed to have the ability to be able to formulate somewhat of a plan in terms of making sure that her husband, Patrick, would be away from the household for a sufficient part of times, or sufficient enough time for her to commit the homicides. You know, how this is going to play out once the experts get up there is going to be fascinating. And I'm telling you, there are no cases that strike to the core of what I'm about as a defense attorney than insanity defense cases and or mental health defect cases. Because if you watched my channel, if you watched our channel, you know that I am so firmly entrenched in the concept that the state, by and large, and I'm talking about the government, by and large, refuses to accept the fact that mental illness is a real thing, that mental illness is typically either in addition to or standalone the reasoning behind why many crimes are committed. And anytime that can be put on trial, I'm here for it. And this case is going to very much like it's this is a case in Reddington is one hell of an attorney. That guy is going to put on one hell of a defense. I promise you that. That guy's not going to be limping into that courtroom. That guy is going to be in there and he's going to put on one hell of a defense. And I'm here to tell you, you need a skilled attorney. You need a very seasoned, skilled attorney in order to go into a courtroom and convince 12 jurors to give that verdict when you had that result. That's it. I mean, we all know the horrific nature of this crime. You know, this mother ended the lives for 3 beautiful children. It's unthinkable. We can't, as a parent, I can't even contemplate it. My mind will not allow me to go there. It will not allow me to go there. I can't even understand how somebody can do that, which begs the question. This woman who has, throughout the entirety of her life, shown absolutely no signs of any kind of mental illness, and leading into this, she's shown no aggression. She has no criminal history whatsoever. It's inexplicable. And when something inexplicable happens, you have to start looking at the brain. You have to start looking at the brain. Like like if you don't look at the brain and you just look at the facts of a case like this, we're not accomplishing anything. We're not moving the needle forward in our country in terms of acknowledging that mental illness is a real thing. As hard as it's going to be for jurors to listen to the facts of this case and have to look at the pictures of these beautiful little kids whose lives were stolen from them by the person who's supposed to care for them most, and who I'm sure did. It's going to be an epic battle to get this message of what they're going to be trying to argue through to that jury, to the point where they're not hearing it, but accepting it. Accepting it is what is required here. So to establish that the defendant has the substantial capacity to appreciate the wrongfulness or criminality of their conduct, the Commonwealth must prove beyond a reasonable doubt that the defendant appreciated, that is, that the defendant knew or understood in some meaningful way that their conduct was either illegal or wrong. And that right there encapsulates how difficult this defense is. It is, if you ask any defense attorney that's tried cases in this country, and if they've ever had to try to employ the insanity defense, they will tell you that it is roundly considered to be the defense of last resort. That's it. It's like because it's so hard to convince a jury. And when you have that right there, when you're talking about milliseconds of time is what matters in a case like this. I mean, if she is having some kind of psychotic episode momentarily where she's hearing voices or whatever happened with her when that went down, but then minutes later she's realizing what she's done, that does not mean that she was not mentally broken, that she was not capable of having criminal responsibility in that moment in time. I mean, like, you can't look at days. It's not a day-long evaluation. It's not, oh, she took the kid to the doctor in the morning and she seemed normal. It ain't that. It's just not. You know, and the challenge here is that we know so little about the human mind that it's difficult for psychologists or psychiatrists to get up on the stand and explain it in a way that resonates with jurors, especially when you have jurors that have never had any kind of firsthand experience, either themselves or a loved one or a dear friend that has gone through mental illness. They just don't understand it. They just don't understand it. So it's an important trial. I'm telling you, it just is. It's got bigger ramifications than just this one case. Like it's a case to where, man, and I don't envy those 12 people that are going to sit in that box. Yeah, I mean, keeping them out, Brooklyn, is the challenge, though. You know, it's like we get such limited information in terms of our jury questionnaires, you know, and voir dire is, you know, you do the best you can with it in terms of trying to get into the mindset of the juror. But man, it's like you can't really know. You're going with your gut. And more oftentimes than not, your gut, when it comes to picking a jury, is wrong because you're doing nothing more than making an educated guess that this person's going to be capable of sitting there in judgment without a preconceived notion being at the forefront of their mind. So you've got to establish that the defendant had the substantial capacity to conform their conduct to the law's requirements. The Commonwealth must prove beyond a reasonable doubt that any mental illness or defect that may have existed at the time of the alleged offense did not deprive the defendant of their ability to behave as the law requires. That is, to obey the law. I mean, when can you make the argument that the thing speaks for itself? The acts in which she committed speak for themselves. There is no explanation that exists in the world other than she had a mental defect at that moment in time that would explain what she did. This isn't going to be a case where you're going to be hearing about her wanting to have another life with some other dude or any of that bullshit. It's inexplicable. It belies everything that this woman was in her entire life. Everything. As far as I'm concerned, not only should the hospital be put on trial, but the pharmaceutical companies should be put on trial for the shit that they push on us all the time, constantly. With really only one motive, and that's not to make us better. It's to get our money. So to summarize, if the Commonwealth proved beyond a reasonable doubt the defendant did not have a mental disease or defect at the time of the alleged offense, the Commonwealth has satisfied its burden of proving the defendant was criminally responsible. Alternatively, if the Commonwealth proved beyond a reasonable doubt that even if the defendant did suffer from a mental disease or defect at the time of the alleged offense, the defendant nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of their conduct and to conform their conduct to the requirements of the law, the Commonwealth has satisfied its burden of proving the defendant was criminally responsible. Now imagine when you're a juror sitting here trying to wrap your mind around this instruction. When you plug those facts into it, when you plug what happened into it. Remember that there is no burden on the defendant to prove that they lacked criminal responsibility at the time of the offense. Rather, the burden is on the Commonwealth to prove beyond a reasonable doubt both that the defendant committed the offense, it's no problem here, and that the defendant was criminally responsible at the time that they committed the offense. If you have a reasonable doubt whether the defendant committed any one of these required elements of the alleged offense, you must find the defendant not guilty. If you have a reasonable doubt whether the defendant was criminally responsible at the time of the offense, you must find the defendant not guilty by reason of a lack of criminal responsibility. So they cited some cases here. A defense of a lack of criminal responsibility may be raised by, quote, any evidence which, if believed, might create a reasonable doubt concerning the defendant's criminal responsibility at the time of the crime. Expert testimony is not always required to raise such a doubt. The defendant may rely on the facts of the case. This court's view has consistently been that where the appropriateness of an insanity instruction is marginal, the better choice would seem to be to err on the side of giving it. Once the issue of insanity has been raised, the Commonwealth must prove beyond a reasonable doubt that the defendant was sane at the time of the crime. At the time of the crime. I mean, how do they do that? The act in and of itself, to me, is insane. The act, what she did, is insane. The Commonwealth must prove the defendant's substantial capacity to appreciate the wrongfulness of his conduct and his substantial capacity to conform his conduct to the requirements of the law. The judge may not limit an instruction on lack of criminal responsibility to the specific medical diagnosis raised by the defense's psychiatric experts, since the burden of proving insanity or proving sanity remains on the Commonwealth, and the jury is not bound by any particular definition of mental disease or defect. And then they've got some supplemental instructions, which I don't think will apply here. Intoxication, I don't think that that will apply. But the drugs, so I take it back. So a defendant's lack of criminal responsibility must be to a mental disease or defect. Intoxication caused by the voluntary consumption of alcohol or drugs is not by itself a mental disease or defect. Where a defendant lacks substantial capacity to appreciate the wrongfulness of their conduct or to conform their conduct to the law solely as a result of the voluntary intoxication, then the defendant is criminally responsible for their conduct. However, the consumption of alcohol or drugs may trigger or intensify, make worse, a defendant's pre-existing mental disease or defect. If it does so, and the mental disease or defect then causes the defendant to lose the substantial capacity to appreciate the wrongfulness of their conduct or to conform their conduct to the requirements of the law, the defendant is not criminally responsible for their conduct. There is one exception to the principle just stated. A defendant who loses the substantial capacity I have just described after consuming drugs or alcohol, who knows or has reason to know that the consumption would trigger or intensify a mental disease or defect or condition that could cause them to lack that capacity, is criminally responsible for their resulting conduct. In deciding what the defendant had reason to know about the consequences of their consumption of drugs or alcohol, you should consider the question solely from the defendant's point of view, including their mental capacity and past experience with the drugs or alcohol. This trial is going to be a banger. That hospital, those like Mandy sent me the article, which I wish I could read to you in this live, but it would take an hour. It's in the New Yorker. It's a phenomenal article. They're interviewing Patrick, her husband, and he is talking about the experiences that they had going into that hospital, where he's begging them essentially to quit just pushing pills on my wife. You're turning her into a zombie. You're fucking with her. And they just kept shoving the pills at him. How does that correlate with this instruction? I cannot wait for this trial. Thank you, Dizzy. This wasn't even on my radar until Dizzy, like, we were having a team meeting via text this morning, and Dizzy's like, "You want to take a look at this case?" And I'm like, "Yeah, what is it?" And, she tells me just the fact pattern, the simple, horrible fact pattern. And then she starts sending me the goods. And I'm like, man, in. But you must keep in mind that where a defendant at the time the alleged offense was committed had a mental disease or defect that by itself caused the defendant to lack the required substantial capacity, the defendant is not criminally responsible for their conduct, regardless of whether they used or did not use the drugs. That is true even if the defendant did use alcohol or drugs, and the alcohol or drugs used made the symptoms of the defendant's mental disease or defect worse. And even if the defendant knew they would make the symptoms worse. And so it says, pick up here if there's no evidence the defendant's knowledge that the consumption of the drugs or alcohol would trigger or intensify a mental disease or defect. Now, she is taking as prescribed. You know what I mean? Oh, did I make a dizzy like voice, Allie? Is that what you're saying? Wow. Yeah, I thought you were the one that always had my back, girl. To summarize, in order for the Commonwealth to meet its burden of proving that the defendant was criminally responsible at the time the alleged offense was committed, that is, that the defendant did not lack criminal responsibility at that time, the Commonwealth must prove at least one of the following four facts beyond a reasonable doubt. One, that the defendant did not suffer from mental disease or defect at the time of the alleged offense, or two, that even if the defendant did suffer from a mental disease or defect at the time of the alleged offense, the defendant nonetheless retained the substantial capacity to both appreciate the wrongfulness of their conduct and to conform their conduct to the requirements of the law, or three, that the defendant, if the defendant lacked the substantial capacity to appreciate the wrongfulness of their conduct or to conform their conduct to the legal requirements, the defendant's lack of such capacity was solely the result of voluntary intoxication by alcohol or other drugs. So it says here, whether the evidence of defendant's knowledge of the consumption or drugs of alcohol would trigger or intensify a mental disease or defect. How does the fact that at least two of these drugs had black box warnings saying that suicidal/homicidal ideations is a possible side effect, yet they're being prescribed to her? I'll submit to you that if pharmaceutical companies are making drugs that make people suicidal and or homicidal, that the wrong person's on trial. That if the defendant lacks substantial capacity I have just described due to a combination of a mental disease or defect and voluntary consumption of alcohol or other drugs, which the defendant knew or should have known would interact with the defendant's mental disease or defect and cause the defendant to lose such capacity. If the Commonwealth has failed to prove at least one of these 3 or 4 facts beyond a reasonable doubt, then you must find the defendant not guilty by reason of lack of criminal responsibility. The consequences. So this is what happens. This is what happens if they come back with a not guilty verdict. Your decision must be based solely on the evidence and the law of this case without regard to the possible consequences of your verdict. You may not consider sentence or punishment in reaching your verdict. You are, however, entitled to know what happens to a defendant if found not guilty by reason of a lack of criminal responsibility. A judge may order the defendant to be hospitalized at a mental health facility for a period of observation and examination. During that period, or within 60 days of the verdict, the district attorney or other appropriate authorities may petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital, initially for a period of 6 months. At the end of the 6 months and every year thereafter, the court reviews the order of commitment. If the defendant is still suffering from a mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitments as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of his or her life. If at some point the court determines that the defendant is no longer mentally ill and dangerous, the defendant will be discharged. The district attorney must be notified of any hearing, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. So then they go through some more case law. I got some notes. So, I mean, that pretty much lays it out for you. I mean, y'all can see that this is going to be, it's going to be on one. It's going to be a hell of a case. And I'm here for it for certain. And I hope that you guys are too. I think it's an important case. I really, really do. I just think it's a case that should be watched carefully by everybody. All right. So I'm going to dip now because I've got a members only live. Stepping away from the true crime for a minute. I'm going to have my beautiful 12-year-old on with me. We are going to do a members only, patron only. And I've put that link in the community notes. You can just click on the link there if you're going to join us. And we hope that you do. We think it's going to be fun. I think that the Mark Twain letter to his daughter is wonderful. I absolutely love it. And I performed it with my daughter. Actually, it was Santa Claus. But it'll be worth 15 minutes of your time plus whatever time we decide to spend. Plus, I'm also I think we're going to do a 1-minute mystery for some stickers during that. First person who comes up with the answer. So I hope if you're not members, maybe you'll consider it and you'll come hang with us. If not, I hope that our current members do come and hang with us. I think that you guys will enjoy it. Yeah, 8:30 Central is when it's going down, y'all. And as for our patrons who are not members over here at YouTube, I've posted it over there as well. The link is there. You just click on it. It'll bring you right to the live. And it's the first one, the first of many. I'm going to start really picking up speed with these members only things. You guys deserve a little extra love because, you show us the love in a financial way. So that has value to us. And as much as we love all of you equally, I feel it's incumbent upon me to give just a little bit more to those who are kind enough to donate their hard-earned money to us, because it really shows us the appreciation of what we do over here. So we're very thankful to it. And I want to start showing that more frequently. So that's what I'm going to do. All right. I'm going to go real quickly DSN, as always, thank you for that $5 super sticker. We always appreciate it. Miss Shorty, I love you. I'm so glad you came to hang with us for this one. If you guys have not subbed over to Miss Shorty's channel, I'll be checking. I'll be checking. Get over there and do it. I did a live with Lisa. What was that, Lisa? A month ago, something like that. It was great. She's awesome. She was born to be a creator. I highly, highly recommend you go over there and get subbed because she puts out a lot of great content. I mean, I like her. What is that thing you always say, Lisa, on your thumbnails? She'll name like a person and she says, "We have to talk." I just think it's creative and fun. So thank you for being here. Thank you for being a member for 6 months too, Miss Shorty. I appreciate you. Thank you for that $5 holla, and thank you for being thankful we're covering this. Thank Dizzy. It's all Dizzy. Dizzy gets all the love, all the credit here. I did not even know it was a thing. And I love getting a case like this early on. And I'm dead serious. I enjoyed being boots on the ground for the Allen case. I liked being in the courtroom. I liked being on the other side of the bar for a change. Not having the pressure of trying the case is fascinating. And I can't wait to be boots on the ground for a trial where I don't have to take notes the entire time, to where I can actually watch what's going on in the courtroom as opposed to looking at a pad of paper the whole time. I'm excited about it. Miss B's Crafting Life, member for 9 months. Thank you. Thank you. Thank you. Thank you. 100 times over. We love having you. We really do. Emily, begging you to get rid of the beep in the intro. Love y'all. I'll have to listen to it. I don't know where it is. It's not, our song is the original. If those of you who like our song, our intro, my producer Darren put that together. I love it too. I think that the beeping sound might be something that we might be able to ace. It's not a part of the sound, but to be honest with you, when that intro is going, I'm frantically trying to get ready for the live, so I don't even hear it. So I'll take a listen to it. If it's in the song, I'll tell you right now, Emily, you're shit out of luck. If it's something after the song, maybe we could do something with it. Darlene D, $5 holla. Thank you so much. Am I correct in understanding they charged her in less than 24 hours? It's a very quick turnaround. It's one of those cases, it's like, what is a prosecutor to do? You've got three small children whose lives were stolen from them. It was, by all appearances, done by their mother. They're going to make an arrest in that case. They'd rather figure it out at trial whether or not she was mentally ill or had a mental defect at the time. They're certainly not going to arrest her. Could you imagine the outcry from the public? Oy vey, it'd be a lot. Be intense. And always remember, prosecutors are the government, and the prosecutor or district attorney, who whatever it may be, depending on where you live, they are an elected official. They are politicians. They have to answer to the electorate. They have to answer to the people. In a case like that, if they don't make an arrest and charge her, then nothing comes out about what happened there. It's like they almost have to do it. Now, that doesn't mean that they have to go to the mat and go to trial once they start learning about what's going on. There is going to be a time during the pretrial litigation in this case wherein they're going to get reports from who I am assuming are going to be very qualified expert witnesses who are going to give very qualified opinions as to what was going on in her mind, that may give them pause, that may say, hey, you know what? Let's talk. Let's go to the table and talk. So thank you for that, Darlene. I appreciate it. Cat Coco 6, $5 holla. Appreciate you. Thank you for being compassionate about postpartum depression and psychosis. It's so misunderstood. It really is. It's got a very, very near and dear place to my heart. It was one of the biggest things that Allie and I advocate for on behalf of our clients in those courtrooms. trying to talk to these prosecutors who just have blinders on, oblivious. It's just it's a piece of paper. They did bad. Let's prosecute them. We need a conviction. It's like robots. That's why anytime I see a prosecutor that's got some compassion, they blow my mind. I'm like, oh my God. I can't believe it. It shouldn't be that way. Davey, thanks. Dizzy, Bob, and Allie for shining a light on this case and postpartum depression, anxiety, and psychosis. Our pleasure, Davey. Thank you for being here in the chat. We appreciate you. Ariel, member for 9 months. Thanks, Bob. We're all thankful for you. I am more thankful for you guys. You guys, and I see it in the chat every single time that we have a live, that new people that come in here are like, wow, this chat is awesome. Yeah. Yeah. And that's y'all. I mean, I flat out, I coined it. No one else did. The best chat in the land, unequivocally, is right here. And that's y'all. I don't have a damn thing to do with it. My mods are amazing. My mods make sure that it stays cool, calm, and collected and civil. And we're no echo chamber. We're really not. I argued for a living. Allison argues for a living. We love arguing. We love it. This is not a place where you come to just kind of scream your opinion out and expect to not get anything back in return as long as it's civil. I love it. That kind of civil discourse is what makes us human beings. It's what separates us from the animals. So debate is excellent. Debate is excellent. We're allowed to have our own opinions. Come informed. Because I'll tell you one thing. This is an informed chat. We got some smart folks in here. You know, so if you're going to come with some bullshit, you're going to get called on it. That's it. And if you get ugly, you get bounced. It's pretty simple. Just be cool, man. Just be cool. And you guys always are. And I hand that, all of that credit goes to my mods who I love. And I thank you so much. Once again, double duty. I feel pretty confident. You guys are more than welcome to mod for our little fun thing in a little bit, but you don't feel it's necessary. But I love having you all there. I love having you all there. So you guys are amazing. Thank you so much. We really appreciate you. I hope that this was informative. I hope that you learned something about a case. I think it's going to be a very, very important case in a lot of different ways. And thank you so much, Dizzy, for getting me all the deets, getting me just a phenomenal way to present this case. It made my life so much easier. I can't even tell you how thankful I am for it. So thank you guys. Remember, on the way out, if you'd be kind enough to just make sure to smash that like button, helps get us in the algo. Make sure you subscribe, because we're loving the growing. It's good. It's good. It's really good for us. And we think we have some pretty good content here. So we hope that you guys spread the word. It's always the best way. Word of mouth is always it. And, when you guys share and subscribe, and I heard download. I heard if you download lives, that also helps. And if you're on replay crew, please throw a comment in the chat. Even if it's just say replay crew, that gets it churning too. So you guys are amazing. Oh, look at this. Sherry, $10. I'll appreciate that. Appreciate the mods for getting those that were not being classy out of the chat. Love no echo chambers. Same. I mean, it's simple. Like, nobody's going to come at my wife. Nobody's coming at my wife. The way I look at it is, if you wouldn't say it with me standing 2 feet in front of you, keep it to yourself. And I have a feeling that a lot of people wouldn't be saying shit about my wife if I was 2 feet in front of their face. I'm just guessing. Me, you can come at me. I got thick skin, but nobody comes after my woman. Know what I mean? All right, y'all. You guys are the best. I love you. I love you. I love you. I love you. Come back at 8:30 if you're members. Come and hang with us. I think you'll dig it. It'll get you in the holiday spirit. I promise. Can have a little giveaway, a little fun, little murder mystery. It'll be a good time. And you'll get to hang with Scout, my 12-year-old, who is the sweetest kid you'll ever want to meet, and super cute to boot. Thanks, guys. Love you, because without you, I'm just an old man talking about a whole lot of cases.